Welcome back to Big News. A European university holding pharmaceutical patent applications in several countries negotiated a license option agreement with a European pharmaceutical company. The pharmaceutical company exercised the option and the parties started to negotiate a license agreement. After 3 years of negotiations, the parties were unable to agree on the terms of the license. At this point, the parties submitted a joint request for a mediation. Both parties decided that mediation was the best way to meet an agreement. And they were right. After just one session, the mediator helped both parties to identify the issues and deepen their understanding of the legal circumstances. On this basis, the parties continued direct negotiations amongst themselves and reached a settlement agreement. Back to Larry for the weather.
Breaking news. Good evening and welcome back. In a high-stakes legal battle that gathered global attention, tech giants Apple and Samsung faced off over allegations of design and software infringement in 2012. The heart of the dispute lay in Apple's accusation that Samsung copied its smartphone and software features. Court-ordered mediation brought a glimmer of hope. The primary reason for this step was to foster negotiations and potentially safeguard business relationships. However, despite their best efforts, their mediation did not result in a settlement. In 2012, the jury found that Samsung had indeed infringed on several of Apple's patents related to smartphone design and software. Samsung was ordered to pay over $1 billion in damages to Apple. In conclusion, while mediation was explored, the final resolution of its high-profile case came through the court system, with Apple securing a victory in the initial trial.
On September 2nd, 2022, the Supreme Court of Ukraine deliberated on a case to determine if the New York Convention applies to the enforcement of awards in Ukraine that were issued in arbitration proceedings under the Convention on the settlement of investment disputes between the state and nationals of other states. The decision could have significant implications for enforcement of arbitration awards in Ukraine, and potentially impact foreign investment in the country. A decision made by the court is still pending.
Hello and welcome to the Generic News Channel. My name is Jonathan Quill and our story today is about the Boston Police Patrolmen's Association and the city. Here are the key points. First, the issue being mediated or arbitrated is the negotiation of a new contract that includes reforms sought by Mayor Michelle Wu's administration. Second, both parties have opted for arbitration after failing to reach an agreement through negotiations. Now, why arbitration? It's the last resort when negotiations reach a deadlock. In this process, each side selects one arbitrator and they jointly choose a third arbitrator. But here's the crucial part. If the arbitrators don't include the reforms the city wants, Mayor Wu hinted that they might not present the award to the city council. In terms of Mayor Wu's goals, she focused on operational changes, office well-being, disciplinary system revisions, and police detail work requirements beyond just salary levels. In conclusion, this arbitration process holds immense significance for both the city and the police union, as it aims to shape the future of their working relationship.
Welcome to the breaking news of the court case of Jennifer Gardner versus Ben Affleck. But it wasn't a court case because they used a mediator. After 13 years of marriage, Jennifer Gardner and Ben Affleck decided to get a divorce using a mediator. Using a mediator helped cause less drama and easier for their children, Violet Ann, Sophina Rose, and Samuel. Going to court would have caused too much drama, and they would have had a much more public opinion on them instead of mediator being a private, more meetup, not a huge event. The mediator was successful because it was a mutual decision between the two of them to get a divorce, and they had been trying to keep the relationship afloat years prior to getting a divorce.
Welcome to Channel 5, folks. The issue being meditated today was a defamation lawsuit brought by Dominion Voting Systems against Fox News. Dominion Voting Systems was seeking a $1.6 million in damages, alleging that Fox News had spread false claims that their voting machines had been used to steal the 2020 presidential election from Donald Trump. The services of a meditator were used in this case. Jerry Roscoe, mentioned in the article, served as a meditator. The parties chose meditation because they were unable to resolve their differences and reach a settlement through negotiations on their own. Meditation is often chosen as means of resolving disputes when the parties want to avoid a lengthy and continuous court trial, and are willing to work with a neutral third party, the meditator, to find a mutually acceptable solution. The meditation was ultimately successful after several rounds of negotiation, facilitated by the meditator. Fox News agreed to pay $787.5 million to Dominion Voting Systems. They also issued a statement acknowledging that certain claims about Dominion were false. As a result, the case did not proceed to court, and a settlement was reached through meditation.